Hello everyone, welcome to Court with Krissy. Since life comes pre-installed with plenty of problems, here is a tip. Try not to muck up your plea deal. I hope you like it. Court with Krissy is now in session.
Thank you very much for being here, Ms. Larson. My name is Judge Hesslink. We are here today on a status conference. I'm informed by the staff that the last time we were here, which was, I believe, January the 13th, we had some technical difficulties with our recording of the equipment. Most likely what that means is I forgot to press the appropriate button to make things record. So what I'm going to do is I'm going to re-tell you what the charges are to make sure that you understand that and we can record that. You were charged in a complaint with on or about December the 11th of 2024 in count 1, operating with your license suspended, in that you operated a motor vehicle on a highway South Old 27 while your operator's license from the state of Michigan was suspended or revoked. And that occurred within Otsego Lake Township and Otsego County. And in count 2, you're charged with failure to stop at the scene of a property damage accident, in that you, being the driver of a Chevy Trailblazer who knew or had reason to believe that you'd been involved in an accident upon Old 27 near Old State Road, open to the travel by the public, did fail to immediately stop the vehicle at the scene of the accident and remain there until you'd complied with the requirements of MCL 257.619, and the accident resulted in damage to a Dodge Ram vehicle, a vehicle driven or attended by an individual. That has a maximum penalty of 90 days and or $100 fine. The count 1 is a maximum penalty of 93 days and or $500 and a vehicle immobilization. So you've been charged with 2 offenses. One is driving with license suspended. The second is failing to stop at the scene of a property damage accident. Do you understand the names of both of those charges?
Yes, sir.
And do you understand the maximum penalties of both of those charges?
Yes, sir.
All right. Mr. Gilo, do we have a resolution of this particular case?
Okay, yes, we do, Judge. She's going to plead guilty. Or strike that. She's going to plead no contest, civil liability to count 2, fail to stop at a scene of a property damage accident. Count 1 would be dismissed. And if there's restitution, she would be responsible for that also.
We simply don't know what that amount is yet.
We have reached out to the victim in this case, and we have not heard back from him. That was back in December. We first sent him information. So with that, Judge, if the court wishes to just proceed and set it at 0, and if in the event we hear from him, we can file a motion, that would be fine with me.
All right, I appreciate that. Thank you very much. Ms. Larson, you've heard what the attorneys have said. Is that what you want to do?
Yes, sir.
All right, I want you to listen carefully, because I have certain rights that I need to tell you about, because you're going to be giving up some of these rights if you enter a plea today. So by entering this plea, you would give up what are known as your trial rights. And trial rights include the right to have a trial by a judge or by a jury, the right to see, hear, and question all the witnesses at the trial, the right to call witnesses yourself to testify on your behalf, and the right to get an order called a subpoena from the court to require those witnesses to appear and give testimony. The right to be a witness for yourself or to remain silent as you choose. And if you choose to remain silent, that silence could not be used against you, because you have an absolute right against self-incrimination. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof beyond the prosecutor at all times. At trial, you also have the right to have an attorney represent you and assist you at that trial, just as Mr. Gilo is assisting you today at this proceeding. Are you on probation or parole for anything?
No, sir.
If you had been, the reason I asked was that may affect you. Plea may affect that as well, but since you're not, we won't worry about it. You would also be giving up some appeal rights, such as the right to automatically appeal if you were found guilty at a trial. But by plea, you have to ask the next court, the appeals court, for permission to appeal. Do you understand all of those rights that you'd be giving up if you enter a plea today?
Yes, sir.
Has anybody promised you anything other than this plea agreement to get you to enter your plea today?
No, sir.
Have you been threatened by anyone to plead today?
No, sir.
Are you doing so of your own free choice and free will?
Yes, sir.
All right. I understand that you're going to be entering a no contest plea, so I'm still going to put you under oath and ask you just a couple questions about that, and then we'll proceed. So if you raise your right hand, please. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Are you asking me to accept your no contest plea in the same way that I would accept a guilty plea?
Yes.
You understand that by accepting a no contest plea, you would have the same consequences as a guilty plea would.
Yes.
And is that what you want me to do today?
Yes, sir.
All right. Mr. Gilo, are you proposing that I review a probable cause affidavit?
Yes, Judge.
Ms. Bruker, is that with your permission as well?
Yes, Your Honor.
And Ms. Larson, do you understand, are you willing to allow me to review what's called a probable cause affidavit? It's a summary of the facts as the prosecutor's office understands them.
Yes, sir.
All right, thank you. Let me do that now. All right, I've had a chance to review the affidavit of probable cause. It does indicate that on or about December the 11th, 2024, that Leah Larson was involved in a two-vehicle crash at the intersection of Old State and Old 27 South, which I can take judicial notice of is within Otsego Lake Township and Otsego County. That she then, according to the witness of the vehicle owner that was stayed at the scene and was involved in the crash with her, that she left the scene. The police investigating officer later called her and called Leah Larson and met with her, and she admitted being in the accident and leaving not due to her not having a driver's license, which meets all of the requirements of failure to stop at the scene of a property damage accident. The vehicle that Ms. Larson was driving was a Trailblazer, a Chevrolet Trailblazer, and the crash resulted in damage to both vehicles, specifically the Dodge Ram truck that was stopped at the scene and talked with the operator, talked with the police. So I find that there was proper factual basis for each of the elements of failure to stop at the scene of a property damage accident and attended vehicle. And we'll accept that plea and find that it was knowingly, intelligently, and voluntarily given. Mr. Gilo, any other factual basis or questions that we need to address?
No, Your Honor, I'm satisfied.
All right, Ms. Bruker, are you satisfied as well?
Yes, Your Honor.
All right, Mr. Gilo, is it your intention to move directly to sentencing today?
We have no objection to that.
Ms. Bruker, any objections?
No, Your Honor.
Let me just catch up on my notes for a minute. All right, Ms. Larson, I'm going to ask the attorneys for their recommendations as to sentencing, and then I'm going to ask you if you have anything that you want to tell me about sentencing as well. So, Mr. Gilo, allocution, please.
Judge, I'd ask you to assess the standard terms and conditions relative to payment of and probation. And I'd ask you to consider a short period of probation until she doesn't have any restitution at this point. But if that might be a problem, we'll have to take a look at that down in the future.
All right, Ms. Bruker, any comments?
Just note for the court, this is another case where a defendant's license has been suspended for a very long time. I know that's a charge that we dismissed, but it's somewhat related because one of the reasons that she fled the scene of the accident was because she was concerned because she was driving on a suspended license. The other thing that stuck out to me in this report is that she says she works for a cleaning business or owns a cleaning business, and that leads me to believe that she maybe drives on a fairly regular basis to get to jobs. So I just wanted to bring those facts to the court's attention.
Ms. Larson, you have an opportunity to tell me anything that you want me to know about yourself or your circumstances or the incident itself. You do not have to make a statement, but you're certainly welcome to do so. This is your opportunity. Please go ahead.
I would just like to say, I have been in recovery for 5 years. I do run a cleaning service, and I do have a driver for that cleaning service. The fact of the matter is it was so close to Christmas. I was so broke, and I had a lady call me and ask me if I could do a walkthrough and clean her house the next day, which would give me Christmas money. There was nobody there. I made the wrong decision and decided to drive myself. I am in the process of getting my license back because it has been a long time. I do have over 5 years of sobriety, and I'm sorry I didn't make the right decision that day. I pray every day to make the right decision, and I assure you I will not be driving until I get my license back.
All right. Thank you very much. I appreciate that. Congratulations on the length of your sobriety. That's good news. I'm glad to hear that. This is going to be an expensive Christmas lump of coal for you. You got to make you know by now that you simply can't make those kind of decisions. If you're told not to drive, you can't drive. Even if there's a good reason that you might want to drive, you simply can't do it. And this is what happens when you make those poor decisions. So I'm going to put you on probation for a term of 180 days. That will be a probation oversight fee of $180. It's $30 a month for 6 months. So that's $180 for that. There's a crime victim fee of $75, a justice assessment of $50, court cost of $150, local charge of $15, and a fine of $75. That's $445 in total. How long do you think it's going to take you to pay that off?
If you give me a month, I can pay that off.
All right. You have the 6 months to pay that off. So what
I
I'm going to do,
understand.
I'm also going to give you some, you may perform community service in lieu of the fines and costs at the discretion of the probation officer. I'm going to give you 2 days of work camp because I want you to give something back to the community for what you did. And I don't want to make it a huge amount because this isn't the worst crime in the world, but you hurt somebody else. I know that there's no restitution today. You hurt them in their pocketbook. They had to pay at least probably their deductible on this. And even if not, you damage their vehicle by your drive. So I'm going to give you 2 days of work camp to kind of make that up. Restitution may be heard in the future. I'm not going to set any amount today because the prosecution doesn't have that information yet. So they may bring that by motion in the future. And then you'll have the full time period of 180 days to pay that off, but it must be done prior to the end of the probation term. You'll need to contact the probation department at the court. You can reach the court at 731. You want to use the payment number or some different number?
The probation number, or we can require drug testing.
Yeah, we should. One of the standard conditions of probation is that there's drug testing. I know that you told me that you've been sober, so that shouldn't be a problem for you. It will be typically random.
Excuse me, there was no drugs or alcohol involved. I'm not accepting this. No, I'm
Ma'am,
not.
you don't have. Ma'am, you don't have an option. I'm going to impose it simply because I want to make sure that you're continuing to be sober.
I've been all right. All right. But I think I am a businesswoman and I am busy and all right, I got it. I think I want to take back my plea.
You might want to talk to your attorney about that.
Forget it. Just let's go with this. So, drug tests. I don't have a problem with drug tests, but marijuana is legal. And I do smoke marijuana.
All right, ma'am, you're going to talk with the probation department about those requirements, and they'll help you understand what the requirements are. And if you have any issues with that, you can speak with your attorney.
Okay.
Any questions, Mr. Gilo?
Not at this time, Judge.
Ms. Brooker, anything else?
No, Your Honor.
Ms. Larson, any other questions that you have?
No, sir.
Thank you very much. That's all for today.
A status conference today. Have you had enough time to stay in contact with your attorney throughout all of these proceedings?
We did have a conversation about it. I was trying to call him this morning, and I think we had a miscommunication.
Okay, but other than this morning, when you kind of cross paths, you've generally been able to stay in contact with him?
Yep.
So as you know, Mr. Dziuba, we're here on a couple of different things today. I treat this number one as a final status conference. That's where I can hear from the attorneys about what things might need to be ready for trial or whether or not they're ready for trial. And then secondarily, and as importantly, it's set for a plea cutoff. Do you remember that discussion?
Yes, I do.
So to clarify again, Mr. Dziuba, a plea cutoff does not mean in any way that you need to take any pleas. It just means that if you wanted to consider a plea offer, today's the last day that I would permit it. If we go past today, that's fine, and the jury will just determine all of the issues in this case. Do you have any questions about what I mean there?
Yeah, well, not about what you mean. I understand what you mean, but with regards to that, at our last hearing, I had asked for and I understand it's the court's discretion on a lot of this, but I had asked for the variables and whatnot, so that I had a better understanding of what it was, and I Mr. Brown explained it to me, but I never, got it where I seen it to know exactly what it is. And that's kind of what the problem was. Other than that,
here's the issue, and there isn't a problem, but let me explain to you why there isn't.
Okay.
The guidelines are scored by the court and by the court alone. So even if your attorney were to score them and tell you what he thought the guidelines were, number one, what his scoring is might be totally different than what mine is, and mine are what control. Secondarily, those bindings under established Michigan law, those guidelines under established Michigan law are not binding upon the court in any way. So while you might want to be aware of what they are, it really has nothing to do with the plea agreement, because a plea agreement is not a sentencing agreement. A plea agreement, if you plead to this offense, the prosecutor dismissed this offense, and there's some other things that might come up. But nothing in any plea agreement would involve a proposed sentence, because the sentencing, as the attorneys well know, is totally up to me.
Yes, I do.
Well, for the record, why don't you lay out for me and Mr. Dziuba, if you had made any plea offer, what the terms of those offers were?
Yes, Judge, there was a plea offer. In fact, it was placed again on the record at our last hearing. It was entering pleas of counts 1 and 4. There's restitution of $4,290 to the victim. The defendant is currently charged as a habitual fourth. If he was able to pay the restitution at or before sentencing, the people would not be requesting that it be as a habitual second. If he can't pay the restitution at or before sentencing, then the plea offer would be to counts 1 and 4 as a hab to dismissal of counts 2 and 3 and the habitual fourth offender.
So, Mr. Dziuba, is that the plea offer that you were envisioning, or that you had heard and talked about with your attorney?
Yeah, and yeah, I guess.
Well, it's not really an I guess. It's either yes or no. Have you heard that term, that plea offer explained to you?
Yeah, I heard the term. Your Honor, I did hear the term. I don't completely understand it, but I did hear the term, and I just heard it again.
Well, let's go through it again and find out what's missing in terms of the understanding. First, you would plead guilty to count 1, uttering and publishing. That's a felony offense that has a maximum potential punishment of up to 14 years in the state prison system. Second, you would plead guilty to count 4, which is embezzlement, agent or trustee, $1,000 or more, but less than $20,000. That's a felony offense with a maximum punishment of 5 years in the state prison system and or a fine of up to $10,000, or 3 times the amount embezzled, whichever is greater. A consecutive sentence could be imposed for any other conviction if the embezzlement victim was a nonprofit, a person 60 years of age or older, or a vulnerable adult. You would also be pleading guilty to those offenses as a habitual offender, second offender notice. The second habitual offender notice means that the 14-year max is increased. It increases from 14 years to 1.5 times that, or 21 years maximum. The 5-year maximum with the embezzlement offense would then be increased again by 1.5 times, which would be a total of 7.5 years maximum in the state prison system. If you were able to pay restitution in the amount of $4,290 at or before the sentencing hearing, the prosecutor would agree to not sentence you or not have me sentence you under any habitual, meaning the maximums would return back to 14 and 5 years respectively. But if you did not pay restitution in full at or before sentencing, you would be sentenced as that habitual offender second offense notice. And then the benefit of the plea agreement is count 2, the uttering and publishing offense, count 3, the uttering and publishing offense, and the habitual offender fourth offense notice would all be dismissed. meaning the life in prison maximum that you would face for count 1, count 2, count 3, and count 4 would all be dismissed, and you would only be facing a maximum of 21 years for count 1, 7.5 years for count 4, and if you paid restitution in full at or before sentencing, a maximum of 14 years for count 1 and 5 years for count 4. Do you understand the terms of that plea agreement now, more full?
Yes, I do. Now,
Advantage of those offers or not?
excuse me?
Do you want to take advantage of that plea offer or not?
Well, here, I have a question, and the question is this: the question has nothing to do with the guidelines in terms, because I know that's on your discretion, but the variables of where that places me as that's the part that I was interested in, because I know there's a variance in there, and that's what I was trying to figure out where I would score.
Right, try and figure that out, but we're past that point by today, Mr. Dziuba. These charges have been existing for a long time. They were filed in September of 2023. That means within approximately 7 short months, these cases have been pending against you for 2 years. That means as of now, they've been pending for about 17 months. Regardless of the time that they've been pending long enough for you to have these discussions with your attorney. If you haven't, I view that as at the feet of you and nothing else. But to make sure that I'm not missing something, Mr. Dziuba, I'm going to have a conversation with your attorney now about that background. So, Mr. Brown, what can you tell me about the background of your discussions with your client? Not in terms of the specific nature of the discussions, of course, but in terms of your communications overall regarding plea agreement, potential scoring issues, and so forth.
Your Honor, I did go over, that was one of his major concerns. I went over that with him back on November the 16th. Had a very long conversation with him, explained various straddle cells, explained to him the scoring, at least the way I thought it would be scored out. But what Your Honor said, the court has the ultimate authority with that. And he basically was kind of going over the same thing that he's going over in court now. Since then, in all candor to the court, notwithstanding that very good conversation, I have not been able to contact him recently. The phone answers, it's not taking calls at the moment. So I sent multiple text messages. I believe I sent an email. As far as actual conversation, since that last one, middle of November last year, it has been quite difficult.
Mr. Dziuba, anything further in that regard?
Yeah, my phone had been off. As far as an email, I had double checked and been through that on and off periodically, at least twice a month. I have not received any emails. I reached out and made a call on a couple different occasions to his number, and hadn't heard anything back. The latest being this morning. I guess the straddle cell, all of that. That's the part that I didn't. I mean, I kind of understood, and I guess that was the part I was looking for a clarification on.
There is no clarification, Mr. Dziuba. There is no clarification because the guidelines are scored by me and I don't know what they are, so I can't tell you what they are. And I won't score them unless and until you're convicted of an offense, whether that happens at trial or by plea. So your choice is one of 2 things. Number 1, we keep this on for the trial, and you're entitled to your trial on February 20th and 21st. That's one option. That's the option that we're going to exercise and that I'm going to exercise unless and until you tell me right now that you want to take advantage of a plea offer. And if you tell me that you want to take advantage of a plea offer, then it's going to be clear between you and I that the guidelines have not been calculated by me. They will not be calculated by me. They will be calculated by me only after you're found guilty and before a sentencing hearing. And then I'll tell you why I choose to impose whatever sentence I may choose to impose. So do you want me to keep the trial on for February 20th and 21st this year, or do you want to enter a plea agreement?
Well, I guess I kind of want to enter, but at the same time, I have several things that have, with regards to all of this that's occurred that has to do with due process and everything else. And I'm just not I'm not an attorney. I don't understand the legal system in terms of the law or the language of the law.
The time has come, and now it is past for you to take advantage of any plea offer. This matter will continue to trial, and the jury will determine the issues. And if you're convicted, you'll face sentencing. If you're not convicted, you won't. But
Your Honor, I
just this case is too old to continue.
I just said I'm interested in that. I just said I'm interested in it.
Mr. Dziuba, you said that you were interested in it, but And that but has significant meaning to me. So
No.
we're done today. Mr. Dziuba, I'll see you on your day of trial. Mr. Brown, are you ready to proceed to trial on February 20th and 21st?
I am ready on my end. It would be very helpful if I could communicate with Mr. Dziuba, obviously.
Mr. Rolla, are you ready to proceed to trial on February 20th and 21st?
Yes, Judge.
Last chance, Mr. Dziuba. It's a clean yes or a clean no. Did you want to take advantage of the plea offer or did you want to reject it? Yes or no?
Yes, but and there's a but to it. And the but is I want to talk to I would like to have a discussion with the attorney.
There is no but. You've had 19 months or 16 months or 12 months, whatever it is, since 9/20 of 23 to discuss with your attorney. To the extent you haven't, the court does not find good cause to continue this any further. This was set and is set for a plea cutoff. We're done today, Mr. Dziuba, and you're going to have your trial on February 20th and 21st.
We will.
Court notes that I removed Mr. Dziuba. I'm not interested at this point, counsel, in having any further discussions with the defendant about this process. As the attorneys can tell, it's somewhat frustrating to me because we've had this process play out several different times, and I'm not interested in continuing it. It's my view that there's been plenty of time for Mr. Dziuba to get into contact with an attorney, and his failure to do so is not a basis for me to extend the plea cutoff or to do anything other than continue to trial. The court is moving on to the next matter then, which is Mr. Winowicki. And it looks like he's in my waiting room, so I'm bringing him in. The court calls next the matter of People versus Jason Michael Winowicki, file 24-6761 FH.
For the record, Your Honor, Mike on behalf of the people.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. Winowicki.
Thank you. Mr. Winowicki, can you hear the court? Not interested in having further discussions about whether or not you wanted to go forward with the plea, because my view is you had the opportunity for months, if not years, to consider the plea, and you've decided knowingly, intelligently to reject it. However, my discretion, in my view, should always be adjusted given circumstances, and here's why I'm willing to adjust it and consider this today. Your attorney apparently relatively soon after your hearing contacted my staff and asked if this matter might be able to be recalled. Were you aware of that?
Yes, Your Honor.
Do you know why he asked it to be recalled?
Yes, Your Honor.
Why did he ask it to be recalled in your estimation?
It was a misunderstanding that I had of a word in there that I didn't know the meaning of.
What did you misunderstand?
Straddle cell.
Well, did you hear any part of the plea agreement have anything to do with straddle cell?
No, but it was in there in something that he had told me, and I didn't understand it, and I was just trying to gain. I didn't know what it meant. I really, best I can explain it.
Do you know what everything means now in the context of this entire matter?
Yes.
Do you have any questions outstanding whatsoever?
No.
You can probably expect that the question that I'm going to ask next is one of two options. One is trial continues on February 20th and 21st of 2025, and the jury determines the issues. The other is if you want to take advantage of a plea offer and the prosecutor doesn't oppose it, I would still be willing to do that because it's still the same day of the plea cutoff. And I think in fairness to you, if you want to take a plea and if it's clear and if it's intelligible to me, then I would accept it. So Mr. Rolla, if the defense wants to take advantage of a plea offer, do the people oppose it?
No, Your Honor.
Mr. Dziuba, what do you want to do?
I'll take advantage of the plea offer.
Are you sure about that?
Yes.
Is there any question in your mind about what the maximum penalties are under the plea agreement?
No, that's up to the court, Your Honor.
No, the maximums are up to statute, and so we'll go through them line by line. So let's do that first, but did you want to take advantage of the plea offer, Mr. Dziuba?
Yes.
Raise your right hand.
Sorry.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Mr. Dziuba, is there any question in your mind that you want to go forward with this plea agreement today?
No, Your Honor.
The plea agreement calls for you entering a guilty plea, Mr. Dziuba, to count one, which is entitled uttering and publishing. Uttering and publishing is a felony offense, and the maximum potential punishment for that felony offense is 14 years in the state prison system. Are you aware of that?
Yes, Your Honor.
The plea agreement also calls for you to plead guilty as a habitual offender second offense notice. Are you aware of that?
Yes, Your Honor.
The maximum penalty for uttering and publishing as a habitual second rises up to 21 years in the state prison system as a maximum. Do you understand that?
Yes, Your Honor.
Under the plea agreement, you would also be pleading guilty to count 4, which is entitled embezzlement, agent or trustee, over $1,000, but less than $20,000. Are you aware of that?
Yes, Your Honor.
Ordinarily, that is a felony offense with a maximum punishment of up to 5 years in the state prison system. However, Again, you'll be pleading as a habitual offender second offense notice. Are you aware of that?
Yes, Your Honor.
The habitual offender second offense notice means that the maximum would rise up to 7.5 years in the state prison system. Are you aware of that?
Yes, Your Honor.
The court also has the option to fine you up to $10,000 or 3 times the amount embezzled, whichever is greater. Are you aware of that?
Yes, Your Honor.
A consecutive sentence could be imposed for any other conviction if the embezzlement victim was a nonprofit, a person 60 years of age or older, or a vulnerable adult. You understand that?
Yes, Your Honor.
And if I was going to impose 3 times the value of the property taken, then either you must admit the amount that was taken, or it must be determined by a trier of fact at trial. You understand that?
Yes, Your Honor.
The benefit of the plea agreement is if you plead guilty to count 1, count 4 is a habitual second, the prosecutor would dismiss everything else that's been charged, meaning he would dismiss 2 other counts of uttering and publishing. He would also dismiss the habitual offender 4th offense notice. Of course, the benefit of having the dismissal of the 4th offense notice means that each of these offenses, if you were convicted as a habitual 4th, would have subjected you to a maximum of life in prison. Do you understand that?
Yes, Your Honor.
The further benefit of the plea agreement is if you pay restitution in the amount of $4,290 at or before your sentencing hearing, then the prosecutor would dismiss the habitual second as well. Do you understand that potential benefit?
Yes, Your Honor.
If the habitual second is dismissed, that means count 1 has a maximum potential punishment of 14 years and count 4 has a maximum of 5 years. Do you understand that potential benefit?
Yes, Your Honor.
Do you have any questions about any of those provisions?
No, Your Honor.
If you're convicted of count 1 and or count 4, whether or not it has a habitual offender notice, the court will have the sole obligation to store your guidelines and to make sure that those guidelines are accurately scored. You understand that?
Yes, Your Honor.
The court alone then will impose sentence. I will hear from your attorney, I will hear from the prosecutor, I will hear from any alleged victim, and I'll hear from you. But ultimately, sentencing is solely up to me as the sentencing judge. You understand that?
Yes, Your Honor.
Outside of the terms of the plea agreement, has anyone promised you anything at all to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
Do you have any questions whatsoever about any of the things I've said so far?
No, Your Honor.
If you plead guilty, Mr. Dziuba, you no longer have any automatic right to appeal. And what that means is after a guilty plea and my sentencing hearing, you would have to ask for what's called leave to appeal, which could be granted or it could be simply denied by the Court of Appeals. Are you aware of that?
Yes, Your Honor.
If you plead guilty, you no longer have any trial rights. Those trial rights right now include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you would have a right to have all of the witnesses against you ordered to appear at trial, and you would have the right to see, hear, and question them. You would also have the right to have the court order any witnesses of yours to be ordered to appear at trial. You have the right to remain silent during your trial and not have that silence used against you, and you would have the right to testify at trial if you wanted to. But if you entered a guilty plea in these cases, you will lose that right to trial and all of those associated trial rights. Do you understand that?
Yes, Your Honor.
And because you're giving up your right to trial itself, you also necessarily give up the right to challenge other things that you might have been able to challenge if you did have a trial. Do you understand that?
Yes.
Prosecutor claims that with respect to count 1, that this offense happened, the date is simply listed as multiple, but there's a date for a check that's alleged to be March 25th of 2021. Do you think that date is accurate?
Yes, Your Honor.
The date that's listed for count 4 is not specifically listed. Mr. Rolla, can you give me an idea?
That's the last date that's on the complaint, Judge.
I don't
For
see
the
it.
time frame.
I'm sorry.
If you let me pull it up, I'll give that information.
Sure. I got dates of each of the checks for the uttering and publishing, but I must be missing where I'm seeing the.
Or I'll find out in a second. Thank you.
All right. And so, Mr. Dziuba, do you understand the allegations that have been made?
Yes, Your Honor.
The restitution amount is $4,290. Do you understand that?
Yes, Your Honor.
Do you agree that that's an accurate restitution amount?
Yes, Your Honor.
Is it true with respect to count 1 that you were in Otsego County and that you authored or wrote a check to Awaken Federal Credit Union?
I didn't write the check. I signed the check.
All right. And was the payee listed as Kevin Braden?
Yes, Your Honor.
And did you sign it as if you were Kevin Braden?
Yes, Your Honor.
You are not Kevin Braden, are you?
No, Your Honor.
So when you signed that check as if you were Kevin Braden, do you agree that you uttered and published as true a false, alleged, or counterfeit alleged record?
Yes, Your Honor.
And when you did that with the intent to get access to the money. The total amount of that check was $1,050.50. Is that right?
Yes, Your Honor.
And you knew that you had no legal authority to write Kevin Braden's name or sign it on that check. Is that right?
Yes, Your Honor.
Mr. Rolla, did that give you time to find the dates or no?
Not yet, Judge. I'm looking, I don't see that it's actually reflected on the information. I can understand.
Well, and that's all right. We'll see if we can get through the factual basis without a specific date. But at some point, Mr. Dziuba, were you working with or an agent of or an employee of Northern Lights Construction LLC?
Yes, Your Honor.
And while you were working as an agent or employee of Northern Lights Construction, the allegation is that you fraudulently disposed of, without the consent of your principal, Northern Lights Construction, money in a value of more than $1,000 but less than $20,000. Do you understand that allegation?
Could you say that one more time, please?
The allegation is that while you were an agent, servant, or employee of Northern Lights Construction LLC, the allegation is that you fraudulently disposed of, or without the consent of your principal, converted to your own use, money with a value of more than $1,000 and less than $20,000.
And that would,
allegation?
yeah, that would be the check we was talking about, right? Yes, I do.
Well, no, not necessarily the same check. What I want to find out is what did you do that makes you think you're guilty of embezzlement from Northern Lights Construction LLC?
That would be the check.
Well, let's talk about it further. With regard to this offense, you were an agent or employee of Northern Lights Construction, correct?
Yes, Your Honor.
And while you were an agent, you came into contact with or came across a check, several different checks, correct?
Yes, I used to give the payroll checks out, yes.
And so you came across that check, or the checks came into your possession because of or in light of your employment with Northern Lights Construction, correct?
Yes, Your Honor.
And those checks were the legal property of Northern Lights Construction, correct?
Yes, Your Honor.
You then converted those checks to your own use. In other words, you cashed the checks and utilized the money for whatever purpose you decided, correct?
Yes, Your Honor, but yes, Your Honor.
And you did that by virtue of your relationship with the principal. In other words, you're an employee of Northern Lights. That's how you were able to take that advantage, correct?
Yes, Your Honor.
And is it true that at the time you committed both the uttering and publishing, well, first, was the embezzlement committed within Otsego County? Was the embezzlement committed within Otsego County, Mr. Dziuba?
Are we referring to the check? I don't know. I don't understand what that one is.
Well, that's count for the embezzlement agent or trustee.
I can be, I think, some assistance now.
But
The time period we're talking about involving all of these checks, and that gave rise to the embezzlement charge, is between the time periods of, looks like March 25th, 2021 and April 13th, 2021. And since he did convert, he had control over the funds, the conversion and the acting as a, for count 4, that's your time period that you're talking about. It's not just one check, it's the whole.
So did you hear those dates between March
Yeah.
25th of 2021 and April 13th of 2021?
Yes, I do. Thank you for the clarification. Yeah.
Are those the dates that you were employed by Northern Lights Construction LLC?
Yes, Your Honor.
And are those the dates that you fraudulently took control of checks that you did not have the authority to take from Northern Lights?
Yes, Your Honor.
And that total amount of damage or value of those checks was at least $1,000 and less than $20,000, correct?
Yes, Your Honor.
Prior to those offenses being committed in March of 2021, is it true that you were convicted of at least one prior felony offense?
One prior felony for, yes, Your Honor. I have been convicted of prior felonies.
And so, for example, one of those prior felonies was in September 4th of 2018, where you were convicted of delivery of a controlled substance in Alpena County, correct?
Yes.
Counsel, is there an adequate factual basis for count 1 and count 4 and the habitual second?
People are satisfied. Thank you, Judge.
Yes, Your Honor.
Do the attorneys believe the court has complied with the court rule regarding the taking of pleas?
People are satisfied. Thank you.
Yes, Judge.
Are either one of the attorneys aware of any promises, any threats, or any inducements that have not been disclosed on the record?
None but people, thank you.
None by defense.
Mr. Dziuba, based upon what you've told me, I do find that your plea is knowing, voluntary, and accurately given, and there is a clear factual basis to support a finding of your guilt. So I set that plea and enter it, on your record. The next step in the process, I'm going to have you provide your telephone number to Agent Leah. That's so he can reach out to you and set up a meeting. That meeting will result in what's called a pre-sentence investigative report. That document will tell me more about you and more about this background before I impose sentence. So go ahead with the phone number.
And the number that I'm on, I don't know the number. It's that would be the best number.
That's fine. Is the number you just gave a good number?
Yes.
So your requirement is to meet with the department. They're going to call you at that number, but it's your requirement ultimately to meet with them so that they can prepare the report. You understand?
Yes, Your Honor. And now, in case that number, and just a question here, in case that number that you have, I know the number that I'm on. I don't know the number that I'm on, but is there a time frame? And do you have a number that I can contact them on in case that number I no longer have?
Mr. Giulio, do you have a number that he might be able to reach out to you?
And what would be a good time to reach out to you, Mr. Neal?
8 to 5, Monday through Friday.
Good enough. Thank you very much.
All right, thank you. The next step after that meeting, Mr. Dziuba, is you're going to get a separate notice in the mail for a sentencing hearing. That sentencing hearing will be in person, meaning you'll be here in person, so will your attorney, so will the prosecutor, and so will I. Do you have any questions about any of that?
No, Your Honor.
Anything further on behalf of the defense, Mr. Brown?
Yes, Your Honor. I guess I wanted to ask Mr. Dziuba, this is a large sum of restitution. If he thinks he'll be able to have that within a month.
I can try. I can't say that I would have it within a month. It may take me a little bit longer. That was going to be a question I wanted to ask, but I wasn't sure whether or not.
Could you do it in 60 days?
Yes, I'm pretty sure I could.
Your Honor, I would request sentencing for that reason be set out for 60 days with no objection.
Mr. Rowland, do you have an opposition?
No, Judge, obviously it's the people's intent to have the victims made whole as quickly as possible.
Mr. Dziuba, I find good cause to adjourn sentencing until about 60 days from today's date. That will give you a better opportunity, hopefully, to pay that restitution in full, which would benefit you and the victim. Do you have any further questions?
Just for clarification, that restitution was $4,290.
Correct, $4,290.
Okay, thank you. No, I have no further questions.
Anything further, Mr. Rowland?
Just that the court's calling off the jury trial now for the 20th and 21st.
I am, thank you. Mr. Brown, anything further?
No, Your Honor, thank you.
All right, thank you.